Our next topic in Unit 4 Area of Study 2 is criminal procedure. At the end of this topic, you should be able to explain three things: the criminal pretrial procedures and their purposes, and this is going to include bail and remand, as well as committal hearings. Second, you should be able to explain the general purposes of criminal sanctions. And thirdly, you should be able to provide an overview of three types of sanctions, as well as their specific purpose. The specific skills you are going to need to build for this topic is going to relate to description and discussion skills. Specifically, you're going to have to be able to describe the pretrial procedures for the resolution of criminal cases, so focusing on pretrial procedures, and you're going to have to discuss the ability of criminal sanctions to achieve their purpose. In terms of the things you're going to need to know for this topic, you're going to need to know about pretrial procedures, which is going to include the general purpose of these procedures, as well as we're going to specifically look at bail and remand hearings, as well as committal hearings. In terms of the actual trial process itself, there's nothing specific mentioned in the study design, but we'll go over a broad overview because it will be helpful for you. And finally, you're going to need to know about post-trial procedures, which will include a look at sanctions. For the criminal procedure topic, we're going to start with a brief introduction to criminal law to refresh your memory from Year 11. We're then going to move on towards an examination of the general purposes of pretrial procedures, so the sorts of procedures that happen before a trial begins. We're then going to look at the ideas of bail and remand, as well as committal proceedings, and finally we're going to look at types of criminal sanctions. Firstly, we'll begin with an introduction to criminal law. A crime can be described as an act or omission that is against the law, harmful to an individual or society as a whole, and punishable by law. So some of the elements of crime. For a crime to be committed, there needs to be a guilty act, otherwise known as actus reus, and a guilty mind, otherwise known as mens rea. A person has a guilty mind when he or she intends to commit the offence. Some crimes are strict liability crimes, however, which means the prosecution does not have to prove that the offender intended to commit the crime. So an example of this would be an underage drinking offence in public. The age of criminal responsibility refers to the fact that a child under 10 years old cannot be charged with a crime because it is presumed that he or she cannot commit an offence. So a 10 to 14-year-old is mentally incapable of committing a crime because they are not able to form the intention to commit the offence. This is known as doli incapax and can be overturned if it can be shown that the child understood that what he or she was doing was wrong. There are two main types of crimes. First of all, there are summary offences. These are less serious crimes that do not have to go to trial by jury and are heard in the magistrate's court. Second, we have indictable offences. These are the more serious crimes able to be heard before a judge and jury. Some indictable offences can be heard in the magistrate's court as if they were summary offences. These are known as indictable offences heard and determined summarily. The parties involved in a criminal trial are the state, which is represented by the Office of Public Prosecutions, and the accused, and it's the state who prosecutes the accused. The burden of proof in a criminal trial lies with the prosecution. However, in some instances, the burden of proof is reversed, such as with strict liability crimes. Hence, the accused must prove that he or she did not commit the crime. For example, in speeding offences, this is the case. The standard of proof in all criminal trials is beyond reasonable doubt. The main difference between civil and criminal law lies in the aims of the cases brought before the courts. A criminal case is aimed at punishing the offender, whereas a civil case is aimed at achieving a civil remedy, which is usually compensation. Now we're going to move on to an examination of criminal pretrial procedures and their purposes, which is going to include a specific look at bail and remand, as well as committal hearings. Pre-trial processes are the processes that occur before a case is heard in the county or Supreme Court. Trial procedures are the procedures used by the courts in hearing a criminal offence. And post-trial procedures include the procedures used to determine an appropriate sanction, given the aims of sanctioning. The purpose of criminal pretrial procedures are to assist the police in identifying evidence for the prosecution, to protect the rights of the accused by treating them as innocent until proven guilty, to provide rights to the police to facilitate police investigation, to determine whether a trial should proceed, to determine if the accused wishes to plead guilty or not guilty, to provide an opportunity for the accused to be released pending trial, and to narrow the issues that need to be determined at a trial. Once a person has been brought into custody, there are a number of alternative outcomes for what might happen to that person. Some of these alternatives for future dealings with that person are to be released with no charge, which means the police can release a person without charging him or her with a crime. Alternatively, they could be released and given a caution notice, on the condition that they will be of good behaviour for the next 5 years. This is usually appropriate for first-time offenders involved in minor offences. The offender has to admit to the crime, co-offenders must be identified, and the crime should involve no more than 5 incidents. If a further crime is committed within 5 years, the offender goes to court and the caution note is treated as a prior conviction. Alternatively, they could be released pending summons. This means the suspect can be released pending the charge and summon being served on them at a later date, telling him or her which court to attend and the time of the hearing. Alternatively, they could be charged and then released on bail, or they could be charged and remanded. So this means they are charged and brought before the magistrate's court for a remand application. The court or the bail justice decides if the suspect is to be remanded, which means they are then held in custody, or given bail. This is a flowchart demonstrating the alternative outcomes available for people brought into custody. So first of all, we have an offence committed. Police begin investigating, which might involve questioning, searching, collection of DNA evidence, and surveillance. A suspect is then detained, and at that point there are a number of alternatives available. The police might make a decision not to charge that person, or alternatively, the person could be released on a caution. If they do decide to charge that person, they could be provided with a summons, which means released and then awaiting a later hearing date, or they could be arrested and they could have to make a bail and remand application, at which point they would go to a court and the court would decide whether or not they were remanded in custody or provided bail. We are going to investigate 3 specific pretrial procedures. Firstly, bail, secondly, remand, and finally, committal hearings. For each of these 3 pretrial procedures, you should know the relevant purpose of that procedure, the nature of the procedure, so in other words, what is it and how does it work, and finally, the extent to which it achieves the elements of an effective legal system. The first pretrial procedure we're going to look at in detail is bail. Once charged by the police with an indictable offence, a person is brought before the magistrate's court for a bail hearing. Bail is when a person charged with an offence is released back into society until the conclusion of their trial, and it usually has conditions. If bail is refused, the defendant will be held in remand in a state facility, or in other words, they'll be kept in jail. The purpose of allowing for bail is to uphold the presumption of innocence, as those accused have not yet been found guilty, and another purpose of bail is to allow the accused time out of custody in order to prepare their case. In other words, because we presume that you are innocent until found guilty, we don't want to put you in prison unless it's absolutely necessary. Bail can be granted at various stages of the criminal process. It can be granted at the time of arrest, during the trial, and while awaiting sentencing or an appeal. The procedures for granting bail are the same regardless of which court an accused person will be tried in. Bail can be granted by senior police officers at the station where the person is charged, and this will be the case in about 90% of instances. Alternatively, it can be granted by a bail justice, which happens about 5% of the time, which is usually called in if police refuse to bail or police believe the matter should be heard by someone else. Finally, magistrates in the magistrates' court can grant bail. Again, this usually happens if bail is refused by the police or the police decide to refer the matter to the magistrate. There are a few possible outcomes for when an offender applies for bail. First of all, if an offender is denied bail, they will be kept in remand, meaning they will remain in custody or in jail until the time of their trial. Alternatively, if the offender is granted bail, this means they'll be released into the community to await their trial. They are released on their own undertaking to return, rather than having to be held in custody. If they are granted bail, they could be granted bail with conditions, so conditions that they would have to comply with, or they could be granted bail without any conditions at all. When bail is granted, sometimes the magistrate will require that the defendant comply with certain conditions. So all defendants must be of good behaviour during their period of bail, which includes not interfering with witnesses or committing any further offences. Some further conditions include defendants must provide a surety, which means someone over 18 who guarantees that the accused will attend their trial. They are sometimes required to deposit a sum of money as part of their surety. Another condition is that the defendant might have to check in at a police station on a regular basis, or the defendant might be required not to visit certain locations or people, such as hotels or gambling venues or schools. They might be required to surrender their passport, or not travel outside the state, or to not drive a motor vehicle. Under the Bail Act, it is assumed that bail will be granted unless there is a specific reason to refuse it. That is, if there are exceptional circumstances. If bail is refused, then the defendant will be held in remand in a state facility. Any time spent in remand is deducted from the final sentence if the accused is found guilty. Unfortunately, someone found not guilty is not usually entitled to compensation for any time they spent in jail because their bail was not granted. This is why bail is usually granted. Some situations in which bail might be refused include when the defendant has been charged with murder, treason, or serious drug offences, unless exceptional circumstances exist which would indicate they should get bail. Other situations might include when the defendant is considered to pose an unacceptable risk to society, or is likely to abscond or commit an offence while on bail, or to interfere with witnesses and therefore potentially obstruct the course of justice in their trial. Courts may consider the past history of a defendant, their home environment, possible hardships caused by remand, the strength of evidence against an accused, and the seriousness of the crime. If the accused is charged with some particular crimes, then bail is refused unless the accused can show why their detention in custody is not justified. Some examples include arson causing death, an indictable offence committed while awaiting trial for another indictable offence, aggravated burglary involving the use of a firearm, stalking or family violence offences in certain circumstances, and drug offences. If the court grants bail to a person accused of any of these crimes, the court must provide a statement of reasons. One of the strengths of bail is that it upholds the presumption of innocence by not punishing someone before they're found guilty. However, a corresponding weakness is that some offences, like murder, carry the presumption that bail should be refused, even though all defendants should receive the same presumption of innocence. Another strength of bail is that it allows the defendant to adequately prepare their case and continue to have an income leading up to the trial. However, a corresponding weakness to this is that granting bail may provide the defendant an opportunity to flee, and therefore avoid justice. When reviewing your notes and preparing for your SAC, you should make sure that you check your understanding of this topic against the knowledge and skills required by the study design, and they have been listed on this slide here. The next pretrial procedure we are going to look at is remand. Someone who has refused bail will be held on remand until the case comes to trial or until bail is granted in the future. This means that they're held in custody, or in other words, they stay in jail. If a person who has been held on remand is later found guilty, the time in remand will be deducted from any sentence they are given. Someone who is found not guilty is, however, not usually entitled to compensation for the time they spent in prison. Bail is therefore usually granted and refused only reluctantly. The purpose of remand is to protect the community against the actions of an accused person that the court believes might reoffend, inflict harm, or commit further crimes. And it is to ensure the court that the accused will appear at the next hearing, so that he or she can be tried for the charged offences. A strength of remand is that it allows the court to protect the community by selecting defendants to hold on remand who pose a particular risk. However, a corresponding weakness to remand is that whenever a defendant is held on remand, their basic human right to the presumption of innocence is being denied. Another strength of remand is that it allows the court to ensure that those defendants who are a flight risk turn up to face justice at a trial. However, another corresponding weakness is that holding defendants on remand also jeopardizes their right to a fair trial, as they are less able to prepare for court and cannot earn money in the meantime. The final pretrial proceeding we are going to look at is committal hearings. Once bail has been granted or refused, the next stage of the pretrial procedures are the committal proceedings. Committal proceedings are all the procedures that take place within the magistrate's court as part of the committal stage. The committal hearing is the last stage of that process. While you only need to know the committal hearing, it is useful to know all the other steps in the committal proceedings to deepen your understanding. The filing hearing is the first step in the committal proceedings. This is when you set a date for a committal mention and a time for the service of a hand-up brief. The second step is compulsory examination hearing. The police may apply to the magistrate's court for a hearing to examine a relevant person or to produce a document. The third step is the special mention hearing. This is when you set a timetable for quick and efficient progress of the committal proceedings. If the accused is pleading guilty to all charges, the magistrate can commit the accused directly to sentencing or trial in the county or Supreme Court without continuing any of the other committal proceedings. At a committal mention hearing, the accused is asked how they plead. If they plead guilty, the court will then commit the accused for sentencing at this stage. Alternatively, there are a number of other possible actions. The committal hearing might then be conducted immediately. They might determine whether the matter should be dealt with summarily. They might hear an application for leave to cross-examine a witness, or they might set a date for a committal hearing and hear and determine any objection to disclosure of material. The committal case conference is an informal opportunity for the prosecution, the accused, and the court to discuss the case and attempt to identify the key issues to be resolved. Each of these proceedings that we discussed happen step by step prior to the committal hearing. We don't need to know these necessarily for the exam, they're not on the study design, but it helps to provide some context. What we really need to focus on for the exam and need to know in detail is what happens during the committal hearing. A committal hearing is the final stage of the committal process. It is a hearing to determine whether the prosecution has sufficient evidence to support a conviction for the offence charged. If the magistrate decides that there is sufficient evidence to support a conviction, the matter will be listed for trial in the county court or Supreme Court. If a magistrate decides that there is insufficient evidence, then the accused is usually discharged. The OPP will review these matters, and in some instances, the Director of Public Prosecutions may decide to take the accused person to trial. The purpose of a committal hearing is to determine whether there is evidence of sufficient weight to support a conviction for the offence charged, so that only strong cases proceed to trial in a higher court. Other purposes of a committal hearing are to clarify the legal issues before attending trial, to avoid wasting the time and expense of taking a case to trial that is unlikely to succeed, and to ensure a fair trial by ensuring that the prosecution's case against the accused is adequately disclosed, so that the defence may adequately prepare and present a case. And finally, to determine how the accused proposes to plead to the charge. The committal hearing is conducted in accordance with the standard rules of evidence and procedure. Step 1. The prosecution first presents its case. All the relevant evidence is presented to the magistrate by the prosecution, usually in the form of something called a hand-up brief, which includes a copy of the charge sheet, documents the prosecution intends to produce as evidence, copies of witness statements, interview transcripts, photographs, and a list of exhibits. The prosecution is unable to examine the witnesses under examination in chief, given the witnesses have already given statements. Some witnesses may be required to appear in person to give evidence and be cross-examined by the defence barrister. Not all witnesses who make a statement are required to give evidence at the committal hearing. Their statement will be included in the hand-up brief of evidence which is provided to the magistrate. Step 2. The accused then presents their case. The accused has a right to call witnesses to give sworn evidence. If he or she chooses to do so, the witnesses are examined in chief by the accused or their lawyers, cross-examined by the prosecution, and then re-examined by the accused or their lawyer. The accused is also entitled to make submissions about charges, or, if the accused does not wish to call any witnesses or make any submissions, he or she can say nothing in answer to the charge. Step 3. The magistrate reaches a decision. At the conclusion of all the evidence and submissions, if any, the magistrate must make a determination about whether or not there is evidence of sufficient weight to support a conviction at trial. If the magistrate finds there is evidence of a sufficient weight to support a conviction, the accused is committed to stand trial and released on bail awaiting the trial or held in remand. If the magistrate decides there is insufficient evidence and a prima facie case has not been established, the accused is discharged and is allowed to go free. That is, he or she is not committed for trial. If further evidence is found in the future, the accused can once again be brought before the court as the committal proceedings are not a trial and the accused has not been found guilty or not guilty. The evidence collected during the committal proceedings are called depositions. This is a collection of all the evidence given by the witnesses under oath that can be used in court at a later date. The depositions are then sent to the Office of Public Prosecutions, known as the OPP, for trial to be prepared. Either the defendant or the DPP can choose to skip the committal proceedings and go directly to trial. However, this is usually uncommon. It is known as direct indictment if this happens. A strength of committal hearings is that it protects the defendant's right to be presumed innocent, as the prosecution is forced to prove that they have enough evidence to justify having a trial. A corresponding weakness to this is that committal hearings do not promote a fair and unbiased hearing, as the defendant does not have to show any of their evidence. Another strength of committal hearings is that it enables the defendant to prepare properly by letting them see the evidence against them. However, a corresponding weakness is that defendants can take the prosecution by surprise in the trial and plan responses rather than answering honestly. Another strength is that committal hearings weeds out weak cases and prevents delay to the court. However, the DPP can override the magistrate's finding and proceed to trial regardless, undermining the role, authority, and independence of the process. A final strength to consider is that committal hearings may encourage a defendant to take responsibility for their actions by pleading guilty, particularly if the case against them is quite strong. However, sometimes the DPP will choose direct indictment, which means not having a committal hearing, which can deny the defendant the opportunity to contest the trial. The next few slides contain practice questions and sample answers. You should attempt the practice questions in your own time and use the sample answers to attempt to mark and evaluate your own work.